We're going to go over some of the principles of government that are found in the United States Constitution. The first thing you're going to find is a separation of powers. Separation of powers is the division of the government's power into three branches of government. Now, why did the framers do this? They did it because they didn't want any single branch of government to become too powerful. So the three branches are the legislative branch, the judicial branch, and the executive branch. Now, the legislative branch's job is to make the laws. The head of the legislative branch, or at the very top, is Congress. Congress is made up of two houses. We'll get to that in a second. Now, for the judicial branch, their job is to judge the fairness of the laws. And the top of the judicial branch is the Supreme Court. Finally, you have the executive branch. And the role of the executive is to carry out or enforce the laws, and the head of the executive branch is the President of the United States. So Congress, which is the legislative branch, is made up of two houses. There's the lower house, which is the House of Representatives. In the lower house, the number of representatives from each state is based on the population of that state. So if you have a small population state, you might only have one or two representatives to the House. Or if you have a large population state like California, we from California have 53 representatives because we have such a large population. There are a total of 435 members of the House of Representatives. So to be a member of the House, you have to be at least 25 years of age. You have to have been a citizen of the United States for 7 years, and you have to live in the state that you represent. The other part of the Congress is the Senate. Now in the Senate, there's equal representation for each state. So that means there's 2 representatives or senators from each state for a total of 100. So the small states, the big states, doesn't matter what size they are, they're going to get 2 senators. To be a senator, you have to be at least 30 years of age, and you have to be a citizen for at least 9 years, and again, you have to live in the state that you are representing. To be the President of the United States, you have to be 35 years old at least, and you have to be a natural-born U.S. citizen, which means you're born in the USA. You cannot be born in another country and become a citizen later and be president. You can be born in another country and become a citizen later if you want to be a member of Congress, but if you want to be president, you have to have been born on U.S. soil. Now, how is the president elected? Each state has an election on the same day, and whichever candidate gets the majority of the votes gets all of that state's electors. And then you add up all the electors who are all across the country, and whoever gets the majority of the electors will win the presidency. Now, for the Supreme Court, the way they get their jobs is they're appointed by the president. So the president will appoint a justice to the court, and then Congress actually has to approve or confirm that appointment. One of the important jobs of the judicial branch is to hear appeals cases. So what will happen is there will be court cases that happen in lower courts across the country, and if there are controversial rulings, those rulings can then be heard by the Supreme Court, which will be kind of have the final say in whether the ruling stands or not. So there are 2 ways a case can get to the Supreme Court, either the state route or the federal route. The state route is that something starts in a state trial court, then it goes to a state appellate court, the state Supreme Court, and finally the U.S. Supreme Court. Or if it's a federal case, it'll start in a federal district court, then go to a federal court of appeals, and finally to the U.S. Supreme Court. The Supreme Court's more important power, possibly, is to overturn laws that are considered unconstitutional. So the way this would work is, let's say Congress passes a law and somebody decides that they think it violates one of their rights. That citizen can sue and ask for the Supreme Court to review the law and determine whether it actually works according to the rules set out in the Constitution. And if it does, then the Supreme Court upholds the law. And if it doesn't, then the Supreme Court strikes down the law. So again, unconstitutional is a term that means it's in violation of the rules that are laid out in the U.S. Constitution. Now, as I mentioned in a previous video on the Constitution, we do have a system of checks and balances that helps to make sure that no single branch of government becomes too powerful. So the legislative branch, the judicial branch, and the executive branch all sort of exist in this sort of triangular system of power that works for them. So the definition of checks and balances is the process by which each branch of government checks the other two. And again, it's to prevent any one branch from becoming the most powerful. So for example, judicial review, judges rule laws unconstitutional. That would be a judicial check on the legislative branch. Impeachment, Congress can put the president on trial. This would be a legislative check on the executive branch. The president appoints federal judges. This would be an executive check on the judicial branch. Ruling a president's actions unconstitutional would be something the Supreme Court could do to put a check on the executive branch's power. Congress approving or rejecting the appointment of a judge is the way that Congress has a check on the judicial branch. And finally, the president can veto or reject a law passed by Congress, which is a presidential check on the legislative branch's power. So that is the system of checks and balances. Now we're going to talk about another important concept, and that's that of individual rights. The idea behind individual rights is that people are protected from the actions of the government. And this was important when the Constitution was written, because a lot of the people who were involved in writing the Constitution were very familiar with all of the ways that their own rights had been violated by the British government before the American Revolution. So it was important to them that there was something put in place to make sure that the government was not able to have those same violations. So right after the Constitution was ratified, as we already discussed, the Bill of Rights was also ratified, and that's the first 10 amendments to the Constitution. And what these amendments do is they protect the freedoms of individuals and they place limits on the government's power. And we'll discuss the Bill of Rights in more detail in another lesson. Another important concept is the concept of republicanism. So a republican government is one that is a type of democracy, but it's not a direct democracy. So republicanism is a system that we have where we elect representatives who then make decisions for us. So just to illustrate this, an indirect democracy, which is what republicanism is where you have people right here who would elect a representative who would then represent them in Washington, D.C. in this case, and then that person helps to make the laws. So that's the representative makes the laws, and that's what republicanism is. We do not have a direct democracy. A direct democracy would involve us making the laws directly. So nobody in between us in that process. Again, that's not what we have. We have a republican government. And finally, federalism is another very important concept. And this is where our government really sets itself apart. What we have is a system of shared power. And the power is shared between the federal or the national government, which is the one in Washington, D.C., and all of the state governments. So there are some powers that are given specifically to the states. There are some powers that are given specifically to the central government, which is our national government. And then some powers are actually still shared between those two levels of government. So when we're talking about local decisions for things like public safety, which would be police and fire, education, roads and bridges, utilities, like electricity and stuff. All of those things would be local, and those would be things that are either regulated or legislated by the state. And then the national government is in charge of making decisions that affect the whole country, and also the national government is responsible for enforcing the United States Constitution. It's also important to note that each state has its own constitution, but the United States Constitution is the document that sort of takes precedent over everything. Popular sovereignty. This is another concept. The definition of popular sovereignty is rule by the people. What this means is that if there are things we don't like about our government, we can change it or we can get rid of it. So far in our 200 plus years of history, our government hasn't been bad enough to really abolish, but there have been lots of changes, and a lot of those changes take place every 4 years in elections for president and every 2 years for Congress. Popular sovereignty does have its roots in the Declaration of Independence, which has an important quote relating to consent of the governed. Basically, what that means is you cannot be ruled by a government unless you give it permission to govern you. And that was, of course, not the case with the British government, which was why that was put in the Declaration of Independence. And also, another important historical precedent that goes even further back is the Mayflower Compact, which was signed by the people who sailed on the Mayflower, the Pilgrims, and they essentially agreed to a pact of self-government, and that was the first self-government established in the English colonies. Limited government. What this means is the government can only do things that are in the Constitution and nothing else. So some people think that the Constitution is open to a lot of interpretation, and they're people that we call loose constructionists. The idea of limited government is more of a strict constructionist viewpoint, which means if it's not specifically written in the Constitution, you can't do it. So the idea here is that the government shouldn't be able to get more powerful than it already is, because the Constitution gives guidelines that the government has to follow, and it can't really violate those guidelines or go outside of the guidelines. So this was important again because at the time that the Constitution was written, people who were involved in the framing of the Constitution had lots of experience with what they perceived to be unlimited power in government, and that was with the King of England, who they felt was abusive of his powers because he had unlimited power, and or very slight limitations on his power because there was Parliament as well. But if you look at King and Parliament together, they were able to do pretty much what they wanted with the colonists. And so when the United States decided to send delegates to write the Constitution, they wanted to make sure that that idea of limited government was put in so that they didn't have to worry about a government that was going to tread on their rights again.